Thank you very much, Chris. Good morning, everyone. Whenever I present, my team has always told me that I speak very softly. And so my first message is to the people at the back, if you can't hear me, will you please let me know? What you guys also did was make my task a lot more difficult by all sitting so far away from me. But I hope that you can hear me during the course of our presentation today. For my sins, and because I lost a bet against Albert, he's decided that I should speak on the law and the legal principles, and he will speak on the standards. So I do hope that I give justice to this particular topic. I think this is a topic that an hour is not sufficient. I think we can spend a day discussing these issues and debating the various issues when it comes to both the Audi Alteram Partem rule, as well as the concept of legal professional privilege and issues around confidentiality. As Chris said, my name is Zakir Mohammed. I head up the corporate investigations and forensics practice at the law firm CMS. I also serve as a board member of the ICFP and the chair of its marketing and communications committee. All right, by way of overview, I'll start off with a brief introduction just to set the scene of the work that we as forensic practitioners do. We're all familiar with it, we're all familiar with the challenges that we face. And today we'll be discussing two of the pertinent challenges that all of us would have at some point or the other either come across or been challenged with, or we've had to answer questions around these particular principles, that being the Audi Alteram Partem rule, as well as the concept of legal privilege or confidentiality. I'll talk about two recent judgments. I do have quite a lot of slides, specifically in relation to one of the judgments. I may not necessarily go through all of the slides, depending on how much time we have, but I've included the content because some of that content is relevant. And when we do share the presentation slides with you, it will be a quick and easy reference point for some of the pertinent things that the judges have said in these two particular cases. I'll then close off with what does all of this mean for investigations? And that will pretty much be the lead up to what Albert will speak about. And then I'll open the floor to questions. If there are any questions, I cannot guarantee that I will follow the Audi Alteram Partem rule. All right, by way of introduction, conducting a meaningful investigation. Sorry, just the screen is very, very small. I can't see. Right, that's a lot better.
You can start with
Okay, that's much better. Sorry, I apologize for the technical challenges that we faced this morning. It's been a while since I've done a physical presentation. Over the last 2 years, we've all got used to Zoom and Teams meetings, so I could hide behind my computer and bad Wi-Fi signal whenever we face technical challenges. Today, I can't do that. So like some of the technical challenges that we face, when we do investigations, we do face many challenges. It's not an easy industry for us to operate in. We're always fighting against our clients, fighting against potential implicated parties, fighting against lawyers who try and come up with smart tricks to challenge the work that we do. But at the outset, to conduct a meaningful investigation requires many things. A careful consideration of the initial facts, because that will guide you on the methodology that you would adopt when you conduct your investigation, how you're going to go about conducting those procedures, the order in which you will conduct these procedures. Often people make the mistake of just rushing into interviews without giving careful consideration to whether I should review documentation first, get myself prepared, and then conduct the interviews. Sometimes it might make sense to start off with conducting interviews to gather more facts before you actually go into the investigation. You need to understand what the purpose of your investigation is. Over the last 10 or 12 years, I've often seen people make the mistake of just using the word urgent, or your client is panicking, and then you rush off and you just start doing the investigation without actually planning what you're going to do, what methodology you're going to use, having a sufficient level of attention to detail when you're conducting the investigation, because there's no greater lesson learned than when you're being cross-examined and you realize you may or may not have missed something, because that is what your opposing counsel is going to focus on. Of particular importance today is our impartiality and objectivity, and that is one of the key things that will be challenged if you're ever sitting in the witness box and being cross-examined. What they will always start to do is to attack the procedure before they attack the merits of your investigation. and they will always attack your impartiality and your objectivity. And that is the crux of our discussion today and the Audi Alteram Partem rule is, have you conducted your investigation in a manner that you can sufficiently defend yourself to say that I was objective and I was impartial in the procedures that I followed and in the findings that form the basis of my investigation. Throughout the investigation, you do need to give constant application and thought to the procedures that you're performing, because whilst you may start off with a particular methodology, depending on the information as it is uncovered during the course of your investigation, you may need to change that methodology as new information comes to light. You obviously have to maintain the highest levels of integrity and ethical behavior. That is of paramount importance. When I started off my career, one of the key lessons that I learned and I was taught is that you've built a career for yourself. Over the years, you will build a stronger career. And that career is the means by which you support your families and you build your livelihood. You will build a reputation in your profession. But if you ruin and tarnish that reputation, you ruin your livelihood. And no client is worth that. So always, always maintain the highest levels of integrity and professionalism. You don't have to please all of your clients. As long as you do the right thing, the right clients will come to you and your reputation will always be intact. Ensure that the procedures that you perform are beyond reproach. And I think for those of you that have been cross-examined, it's the biggest lesson, because whilst you're doing the investigation, we're under a lot of pressure. Sometimes the pressure is time sensitive. Sometimes the pressure comes from a client who may have some ulterior motive, but we must make sure that the procedures that we perform can never be attacked because we missed something or we capitulated to a client's particular demands and how we should do our investigations. Now, those are some of the numerous challenges that I've highlighted, and of particular importance today is, and that's relevant to investigations, is when is a forensic report legally privileged? This is a very, very important question because I've seen over the last couple of years, a lot of marketing material saying, come to us to do your investigations because all our reports are legally privileged. That's not necessarily true. Am I required to share the report with any third party? Now, during the course of your investigations or post your investigations, you may be asked for a copy of the report. Are you obliged to share it? Who are you obliged to share it with and why? Or if not, why not? Do I have an obligation to share my report with an implicated party? That's a very, very critical question. Do I have an obligation to interview an implicated party? And what happens if I don't do so? The integrity of your process may be called into question if you don't understand these particular challenges or the answers to these particular questions. Now, starting off with the star of today, the Audi Alteram Partem rule. Some of us may be familiar with this rule. For some of us, this may be a new rule, and it's quite a fancy Latin term. And in the year 2022, we still seem to be using Latin terms. But basically, what does this mean? It means to listen to the other side and let the other party be heard. It is a principle of natural justice. Essentially, it gives the right to parties to any litigation proceeding that no party shall be condemned unheard. Everybody should be given the opportunity to say his or her side of the story. And that is very, very important when we conduct forensic investigations. Ultimately, we are investigating incidents of fraud, corruption, theft, money laundering, cybercrime. Sometimes we might be doing harassment investigations, etc. And it's important that we do hear the other party so that we can get the full facts of the matter, so that we can make a finding that is substantiated by the facts. Any decision taken without listening to both parties can be considered to be against the principles of natural justice. The Audi Alteram Partem rule promotes objective and informed decision making, and it implies that the person who may be implicated or against whom adverse findings may be made must be given the opportunity to be heard. Now, I've spoken about the concept of natural justice. Now, at a very basic level, the concept of natural justice is essence in fair adjudication. Its purpose is the prevention of miscarriage of justice. Now, if you look at a lot of the case law that is developed over the last 30 or 40 years in relation to the concept of natural justice, as well as the Audi Alteram Partem rule, what one would see is that a lot of this case law goes into the administrative law domain, where certain state action was taken against individuals, where certain government departments and the like have made certain decisions against individuals. And so you'll find a lot of the case law around this point sitting in the realm of administrative law as well as the Promotion of Administrative Justice Act. However, in the last couple of years, we're seeing those principles extended to other areas of the law. And we now, in the last 2 or 3 years in particular, are seeing this play out in our forensic industry, in the investigations that we do. Because obviously in some of our investigations, particularly in the private sector, we're not necessarily dealing with administrative action. We're not dealing with administrative decision making. We are not judicial bodies, neither are we quasi-judicial bodies. We are conducting some of our investigations in the private sector on behalf of clients in the private sector, and so that realm doesn't necessarily impact us. However, the principles that have developed on the case law on this point are starting to enter into the private sector domain, and it is very, very important that we fully understand what does this mean for our investigations and how our investigations may potentially be challenged. Now, the Audi Alteram Partem rule was referred to in the case of Dupree versus Truth and Reconciliation Commission. Now, I'm not going to speak about this particular case, but there was a particular aspect of this case where it was summarized quite nicely, and that was, it referred to the Pergamon Press Limited case. And this is one of the reasons why I have a gripe against Albert, because I have to quote these particular cases with very difficult names. Now, in this case, it's a 1970 case. But the reason why I made reference to the Dupree case is because it's a 1997 case. And that 1997 case was obviously heard and decided in our current constitutional dispensation. And the fact that they referred to this 1970 judgment is of interest. And I did like what the judge in this 1970 case had to say, which I will quote in my next slide. Now, in this, and you'll notice that I'm calling it the 1970 case because it's a lot easier than Pergamon Press. Thank you. Chris.
Let's see what I can do here. Just give it to me.
Sorry, the Wi-Fi signal is bad. All right. I'm realizing I'm getting quite old because I can't see the writing on my screen. So I'm going to stand here so that I can see some of my slides. And because I dressed up for you as well. You can have a look at that. All right. So in the Pergamon case, the court was concerned with procedures in an investigative inquiry conducted by inspectors in terms of the Companies Act, right? Now, the directors challenged the inspector's findings and the inspector's process in this particular investigation that they conducted because they didn't interview the directors. Now, the directors claimed that the inspectors should have conducted their inquiry the same as if it were a judicial inquiry in a court of law. Now, this string of cases deals with commissions of inquiry, either in terms of certain statutes and the like. And so what the judge said here was particularly interesting. And for me, it sets the lay of the land in relation to what we're speaking about today. And the judge said, it is true, of course, that the inspectors are not a court of law. Their proceedings are not judicial proceedings. They are not even quasi-judicial, but they decide nothing. They determine nothing. They only investigate and report. They sit in private. But this should not lead us to minimize the significance of their task. They think fit, make findings of fact which are very damaging to those whom they name. They may accuse some, they may condemn others, they may ruin reputations of careers. The report may lead to judicial proceedings. It may expose persons to criminal proceedings or to civil action. Seeing that their work and their report may lead to such consequences, I am clearly of the opinion that the inspectors must act fairly. And for me, this quote from this particular judgment is quite important because you'll see when we talk about the recent judgments, specifically in relation to the VBS case, you'll see that the courts have followed a similar approach. Now, in this matter, Obviously, it wasn't a judicial inquiry, it wasn't a commission of inquiry, but it was still challenged. But I think that what the judge held in this matter is quite apt for the work that we do. When we do conduct investigations, yes, we're not judicial body. Yes, we're not the final determinants of fact, but we do make findings and recommendations against individuals and entities. And sometimes those findings may lead to civil action. It may lead to disciplinary action in the realm of employment law. It may lead to criminal prosecution. And so these are quite significant findings. And even if none of this action is taken against an individual or entity, at the end of the day, it could have a reputational impact on the particular individual and entity. And so it's important that we do act fairly in the work that we do. Now, another important concept in relation to the Alteram Partem rule is, what about precautionary suspension? And I felt that it was important to mention this in today's presentation because whenever we start with an investigation, clients will often ask us, should we or should we not suspend potentially implicated employees whilst you conduct the investigation? And the case law on this particular point has changed, and the current legal position is that there is no requirement in law that employees must be heard before being placed on precautionary suspension. Now, the case law on this particular point previously was that before you suspend an employee, you needed to have a pre-suspension hearing. You needed to allow the employee to make representations as to why they should not be suspended. That position has now changed in law. And the reason why is because a precautionary suspension is not a punitive measure, it's a precautionary measure. It's designed to protect the integrity of the of the investigative process. Because ultimately the determining factor is, do I need to suspend this employee because there might be a risk that they may interfere with the process? And that is an important consideration when an employer is making the determination of whether to suspend or not. And there'll be numerous factors that can be taken into account. Is the person senior enough that they may influence lower employees who may be crucial witnesses in the process? Do they have access to critical documentation that you may need for the investigation, and they're in a position to destroy those documents? Can they manipulate the process in any particular way? And if the answer to those questions are yes, then obviously precautionary suspension is the way to go. So these requirements are that there must be an ongoing investigation, and the suspension seeks to protect the integrity of that process. Now, the only times where it wouldn't apply, or this rule wouldn't apply, is where it's stated in an employment contract that they will be allowed to be heard before being placed on precautionary suspension. It's either part of a company policy or collective agreement or government regulation, but those are the exceptions to the rule. But I think this is quite relevant for the concept or the work that we do when it comes to investigations, because in 90% of the investigations, that is the first question I've been asked: to suspend or not to suspend. And hopefully this will assist when you are also faced with a similar question by your clients in the work that you do. Now, that was just a very high level overview of the Audi Alteram Partem rule. I'll go into a lot more detail when I speak about the recent judgment and how this is played out in our courts. And so, if time permits, I think I'll spend quite a lot of time discussing this particular rule when we deal with those judgments, because those judgments are quite interesting to see how the courts have interpreted and set out the rules in relation to the Audi Alteram Partem rule in relation to investigations. I'll now give an overview of the concept of legal privilege, and I'll speak a bit about confidentiality, which is also important in the realm of investigations. I did start off by saying that the doctrine of legal professional privilege is often misunderstood. And I dare say this, and hopefully will not have a target on my back for saying this, but I've seen it a lot of times in marketing material where, why should you choose us to do your investigations? Because all our reports are protected by legal privilege. And so many are guilty of that. But the reality is that the concept of legal professional privilege is a lot more complicated than simply saying that just because a lawyer does it makes it privileged. Obviously, I would like that to be the case so that I can say that in my marketing material. However, the law is not that simple. Just because a lawyer does an investigation does not automatically mean that that investigation is legally privileged. Also, marking a particular document as or a legal document is legally privileged does not make the document legally privileged. And you'll understand why I say this. Now, sometimes the concept of privileged is confused with the concept of confidentiality. Now, documents or information that is subject to confidentiality is not necessarily legally privileged. Confidentiality is a component of privilege, but it does not establish legal privilege in its own right. Now, this is an important consideration in relation to investigation and the possible disclosure of investigation reports. Now, this is the case because sometimes clients do want to commission an investigation. They obviously do want the reports to be protected from disclosure. Now, the concept of legal privilege goes at the heart of disclosure of that particular document in a particular legal proceeding or other forum. And so clients will look to see, I want this investigation done, but I obviously don't want anybody to have sight of my investigation report. And so they look to privilege. But in our profession, it's very important that we understand what does this legal principle actually mean? In what instances would our reports be privileged? Be whether we are lawyers conducting this investigation or whether we are non-lawyers who have been briefed by a law firm to conduct an investigation, would our reports attract privilege? If so, why so? If not, why not? I have made the point that the reliance on privilege is often misplaced. Now, in a lot of the investigations that I've done, I've had to upfront sometimes tell clients that you must understand your brief to me is that this is a fact-finding investigation. I'm not giving you any advice on the law. There's no litigation contemplated, etc. And so, unfortunately, this report is not going to be covered by privilege. You may potentially have a confidentiality undertaking with your particular client in relation to your investigation and your investigation report, but that is a contractual obligation on your part to maintain the confidentiality of it. But that's not going to protect that forensic report necessarily from being disclosed should some other court or legal process require the disclosure of that particular forensic report. Now, why is the concept of legal privilege important? Now, lawyers always, and the legal system sometimes comes up with very smart ways of achieving certain things. But I think this is a very, very important consideration to bear in mind when it comes to the concept of legal privilege. At the end of the day, for the full and proper administration of justice, in order for lawyers to do their jobs, you do want clients to disclose fully the facts of the case so that you can advise them properly. Now, if we had a system where that communication was not protected in some way, clients would come with half-based facts. People wouldn't be comfortable giving you the full lay of the land for risk that what they say might be disclosed. Now, at the end of the day, if there was forced disclosure, it would ultimately hinder the effective administration of justice, because the concept of a fair judicial system is that a particular individual or entity can seek legal advice with the comfort knowing that that communication with your attorney is going to be protected by legal privilege so that you can give him or her the full facts of the case, and so your lawyer can then advise you fully. Obviously, this doctrine would not apply if you are approaching your lawyer to try and find a way to perpetrate a crime. So legal privilege does not apply in those instances and cannot be used where the advice that you're seeking is in furtherance of a particular crime. It can only be applied where you're legitimately seeking proper legal advice, either to defend yourself or to understand how to legally deal with a particular matter. Now, in South African law, the concept of legal professional privilege is broken up into two parts. The one is legal advice privilege, and the one is litigation privilege. Now, legal advice privilege is any communication between a client and his or her attorney for the purposes of obtaining legal advice. Litigation privilege, on the other hand, is any communication between an individual and his or her attorney or third party when litigation is contemplated or likely to be contemplated. And you'll see when we unpack some of the judgments these become very technical and argumentative terms, like when is litigation contemplated or likely to be contemplated. And you'll see when I talk about the Steinhoff judgment, that became a key consideration that the court considered in determining whether the disclosure of the Steinhoff report should be allowed or not. But I'll unpack that when we speak about the judgment. But these are important considerations to bear in mind in the realm of forensic investigations, because these are the determining factors of whether your report will be protected by legal privilege or not. So in the normal course, one could potentially rely on legal advice privilege if you are conducting an investigation to gather the facts in order to obtain legal advice in relation to a particular issue. One would have to determine on a case-by-case basis whether the investigation itself would fall within the realm of being conducted with the purpose of obtaining legal advice. And so on the face of it, it might seem to be a simple answer, but not necessarily so. And our case law on this particular point will still need some further development to provide further direction, but one needs to bear in mind that this is a very careful consideration, because there are judgments out there where, for example, legal advice privilege was claimed on a report where it was said that, this investigation was commissioned by a law firm, or alternatively, a client instructed a law firm to brief an investigation firm to conduct an investigation so that the law firm could then provide legal advice. And there's been some cases where courts have even gone to the point of saying, well, not all areas of that investigation should be covered by privilege, because not all of the work done in the investigation was relevant to the advice that was obtained. And so there is jurisprudence to that effect. And so it's very, very important to understand that the answer to these questions of legal advice privilege and litigation privilege is not necessarily simple to answer. And so it's very, very important that one is not lackadaisical in saying, okay, fine, I've been briefed by a law firm or lawyers are involved, so automatically it's covered by privilege. I've also seen clients who started copying me on emails because they automatically feel like now, because I'm CC'd on emails on a matter I know nothing about, that those matters are now covered automatically by privilege. And unfortunately, even some lawyers don't fully understand that the concept of privilege. Just copying a lawyer in an email off the bat doesn't make it privilege. I'm often shocked when I see a chain of emails and I'm CC'd in it and I know nothing about it. And then as you go through the chain, you see that it's marked in big, bold, italic, legally privileged and confidential. And I've had to have very difficult conversations with clients to say it's not, because it's a board meeting. Why are you copying me in correspondence relating to your board meeting? I don't know what you guys are discussing. And so that just goes to show how sometimes this concept can be abused. And in the realm of the work that we do, we must be cognizant of this so that we also understand instances where clients might want to try at their very best to grasp onto this concept at all costs. And also, we want to also protect ourselves and the integrity of our process by not getting into unnecessary fights because we didn't raise the questions at the time to say, well, is it actually going to be privileged if I do this investigation at the guise of a law firm? What is the nature of the matter, etc. Now, when it comes to litigation privilege was the defense that Steinhoff had come to in defending its position on producing its particular report. Now, just to unpack that a little bit, what is litigation privilege? Litigation privilege is basically, it kicks off at the point where litigation is either contemplated or likely contemplated or has started. Now, the best way or the simplest way that I was taught to try and identify when is litigation contemplated, and I quote my principal at the time, who said, to try and figure out what that point is when litigation is contemplated or potentially contemplated, when did the hier kom kak letter get served on your particular desk? Because that is the point where litigation privilege is likely to have started. That is likely when litigation is likely contemplated. Because it is at that point that the board or whoever in a particular organization realizes, oh no, I see trouble coming. It could be a letter of demand or some other document that is served where you realize litigation is likely to come to me, be it a regulatory type investigation where you can see that a prosecution potentially might be on the line. It could be a civil litigation where you issued with a letter of demand, or just from the purpose of the letter, you can see that, oh no, something's about to happen and something's about to come. That's usually an indicator of when litigation is contemplated or likely contemplated. So the concept of the right to legal privilege was stated quite nicely in another famous case in 2008, Hunt versus National Director of Public Prosecution and others, Zuma and others versus National Director of Public Prosecution. And in this case, the judge summed it up quite nicely. The right to legal professional privilege is a general rule of our common law which states that communications between a legal advisor and his or her client are protected from disclosure, provided that certain requirements are met. The rationale of this right has changed over time. It is now generally accepted that these communications should be protected in order to facilitate the proper functioning of an adversarial system of justice, because it encourages full and frank disclosure between advisors and clients. This, in turn, promotes fairness in litigation. In the context of criminal proceedings, moreover, the right to have privileged communications with a lawyer protected is necessary to uphold the right to a fair trial in terms of Section 35 of the Constitution, and for that reason, it is to be taken very seriously. The judge then referred to the principles of evidence where the requirements were set out. And there are 5 requirements that need to be met in order for legal professional privilege to apply. The legal advisor must have been acting in a professional capacity at the time. So obviously, if you're at a family bride and you decide to ask your lawyer cousin for advice, that communication is not necessarily legally privileged because he's at a bride. It's out of working hours. The advisor must have been consulted in confidence. So obviously, it must have been between yourself as a client and your lawyer for the purposes of obtaining advice. The communication must have been made for the purpose of obtaining legal advice. So you're not just teasing your lawyer in a communication because you want to rely on privilege for whatever reason. And it must not facilitate the commission of a crime or fraud. So you cannot be approaching your lawyer to figure out a scheme or fraudulent scheme or how to perpetrate a particular crime. And the privilege must be claimed. Now, at the end of the day, the privilege is claimed when a request for that communication or report or whatever the case may be is requested. So it has to be claimed by a particular client. Now, there's certain key features of legal professional privilege. The privilege belongs to the client only. So it doesn't belong to the attorney or any other party. It relates to, or it's the client's privilege. And only the client can waive it, and only the client can claim it. So if there's a litigation process or procedure against a particular individual or entity, it is that individual or entity that has the right to claim the privilege over that communication. Now, there's quite an interesting matter that I'm dealing with at the moment, where certain opinions were obtained, and it's let me try and explain it. It's quite a complex set of facts where we've got our opposing side, we've got an audit firm, and we've got a law firm. Now, the party we're fighting against did not commission the opinion. It was commissioned by the audit firm. The audit firm commissioned these opinions from a law firm in relation to certain contracts. And so these opinions were then provided, etc. We're part of a litigation process, and extracts of these opinions were disclosed by our opposing party, along with extracts of a forensic report. Now, this is quite an interesting set of facts now, because it was as part of the discovery process or the exchange of documents between the parties, we've now come across these big abstracts of legal opinions. And so one of the determining factors is, are we entitled to those opinions or not? Would they be covered by privilege? Has privilege been waived? And what the conclusion that we've come to is we're going to take a fight on the potential privilege defense that our opposing party is going to raise, because the opposing party is not the one that commissioned those particular opinions. It was commissioned by a particular firm, and the law firm provided it to that particular firm. That firm then distributed it to our opposing party and to another firm that was doing the investigation. So we're going to argue that the privilege belonged to the audit firm because they were the client. They commissioned the opinion, not our opposing party. They were not the client, so they can't claim the privilege. At the same time, we're going to take our argument further, and we're going to say that the privilege was waived because those opinions were distributed to several third parties, and it was distributed to our opposing side. And so that just gives you an idea of how sometimes the arguments around privilege can become quite intricate, because we haven't started the fight yet, but we anticipate that once we ask for those particular opinions, our opposing side is going to say, well, they're privileged from production and we can't give them to you. But the point is, it's not your privileged documents. You are in possession of these opinions. And the fact that it was provided to you by the procurers of the opinion means that they've waived privilege. We'll see whether we're successful or not, but I think that we have strong grounds to argue that privilege was waived and the privilege doesn't apply to the opposing side. And so you can see that fights around privilege will always be prevalent. And in the current diaspora of where we're operating in investigations, it's going to become a fight that is going to be had more and more, particularly driven by the fact that currently in South Africa, we have, and rightfully so, a very vocal media industry. And we've also got a very vocal public that is tired of the rampant fraud, corruption, and other scandals that have been plaguing our country. And so these fights are definitely going to come to our courts more and more, where people are going to want more transparency. And, they're not going to want, certain implicated individuals, or let's say fraudsters, hiding behind legal principles for their own purposes, etc. Now, this privilege, interestingly, does not extend to non-lawyers. So even though a particular individual who's not a lawyer has expertise in a particular, let's say, a specialist in another area, but has some experience on legal principles or did a particular legal course, the legal provision will not apply to any legal advice given by someone who's not a qualified attorney. That is the rule of our South African law. And again, it does not apply when advice is sought for fraudulent or criminal purpose. And that's an important one in the work that we do, because unfortunately, we do live in a country and in a world where lawyers themselves are sometimes involved in this kind of conduct, or they are sometimes used as a means to perpetrate further crimes, etc. Right. The difference between privilege and confidentiality is privilege is a fundamental right that is afforded to litigants as a means of resisting disclosure of sensitive and confidential material or information. Confidentiality is a broader concept than privilege. Now, I did mention earlier you might get contractual confidentiality. So, for example, if you've signed a non-disclosure agreement prior to conducting your investigation, obviously there's a contractual obligation to maintain the confidentiality of the process, of the documents that are produced, etc. But there is a contractual obligation. It's not legal privilege. Another concept or thing of confidentiality is that certain kinds of information may by their very nature be confidential. So for example, proprietary information of an organization like trade secrets, etc., are confidential because they are inherently private to that particular business. Now, confidential information is not necessarily privileged. So if you've got a dispute, be it civil or criminal, confidential information is required to be disclosed to the other side, whereas legally privileged is not required to be produced to the other side. Another important point is marking something as legally privileged doesn't necessarily make it so. Just because you may mark a duck as a chicken doesn't make the duck a chicken. It will still be a duck. And this is important because I've seen over the years lawyers and non-lawyers, clients automatically start marking things big, bold, black. If they can highlight it and put neon lights, legally privileged, doesn't make it legally privileged. It's the substance of the information, the substance of the communication, the purpose of the communication, which would make it privileged or not. All right. Now, I'm going to go into recent judgments. I know we've got 8 minutes to 11, but I think we did start a little bit late. So if you'll allow me the luxury of time, I want to just delve into 2 particular judgments in a little bit of detail, because it really shows how our courts have dealt with both of these concepts. I'll start off with the Audi Alteram Partem rule at a practical level, and then we'll deal with the concept of legal professional privilege. And these are quite famous cases, quite recent. Some of us would have read the judgments or read about these particular judgments in the media. The first one is Mampe Daniel Nsizza versus Advocate Terry Matau and the Prudential Authority of the South African Reserve Bank. Because it's quite a mouthful, I'm going to refer to it as the VBS judgment. Now, all of us know about the VBS report, quite a famous forensic report that was published. And this particular case is quite an interesting case for our discussion around the concept of Alteram Partem. Now, when the VBS judgment came out, it's a 148-page report. That was quite an interesting one for me, because the first thing that I thought of when I saw the cover page of the report was that my forensic reports are rather boring. Mine just says investigation into allegations of fraud and corruption. Mine doesn't say the great bankies. But nevertheless, it set the tone for the rest of the report. And I also realized that my drafting is also very boring and very, very to the point and concise. And so I don't think I'll be a novelist anytime in the near future. But it was a very interesting report. And it sparked a lot of questions, it sparked a lot of debate, it sparked a lot of outrage because of what was uncovered during the course of that investigation. But of relevance to our discussion today is this particular judgment and the concept of the Audi Alteram Partem rule, or the right to hear the other side. Now, in this particular matter, Mr. Nsizza was the applicant. The first respondent was Advocate Terry Matau, SC, who was the lead or appointed by the Reserve Bank to conduct the investigation, and the second respondent was the Prudential Authority of the South African Reserve Bank. Now, in this particular case, Mr. Nsizza sought to review, set aside, and have declared as prejudicial and unconstitutional adverse findings made against him. Now, the primary issue which the court had to decide in this particular case was whether the findings, remarks, and conclusions that were the subject of Mr. Nsizza's complaint were reviewable under the Constitution and the Promotion of Administrative Justice Act. Now, obviously, the Promotion of Administrative Justice Act was quite relevant here because we were dealing with the realm of administrative law, because of the fact that this was an investigation commissioned by the South African Reserve Bank. And the issue was that the adverse findings made against Mr. Nsizza were made without affording him an opportunity to be heard. Now, just to give some contextual background into what the first respondent's, or Mr. Matau's, mandate was, he was required to investigate certain allegations of impropriety in VBS Bank. Now, these investigative powers were conferred on him in terms of sections 136, read with section 139 of the Financial Sector Regulation Act. As part of his mandate, he was required to establish whether or not the business of VBS was conducted to defraud depositors or any creditors of the bank, or any other fraudulent conduct, whether VBS's business was conducted, or whether VBS's business conduct involved questionable or reckless business practices or material non-disclosure with or without the intent to defraud depositors and their other creditors, and whether there had been irregular conduct by VBS's shareholders, directors, executive management, staff, stakeholders, and other related parties. So that was basically the mandate that was given to Mr. Matau by the South African Reserve Bank in terms of the Financial Sector Regulation Act. And so he was conferred powers that some of us don't necessarily get when we do investigations, especially in the private sector. Now, during the course of this particular investigation, numerous procedures were performed. And I mention these particular procedures because of the extent of these particular procedures, because that sort of lays the foundation as to why the court had given credence to Mr. Msize's complaints. For me, at a practical level, I mean, interviews were conducted, documents were analyzed, data stored on mobile phones and computers were analyzed, financial transactions and bank statements of those implicated in the misappropriation of funds was analyzed, and documents obtained during search and seizures at VBS's offices and branches were analyzed. And so quite extensive procedures were performed during the course of this investigation. At the outset, it is never my job, or not something that I do, to criticize anybody's investigation, because I fully understand that whenever you're doing an investigation, theoretically, a lot of things are easy, but when you're dealing with an investigation, it can be very, very challenging at times because you're dealing with a lot of constraints, etc. But I mentioned this because this is not an investigation where no interviews were conducted or limited procedures were performed or certain limitations were set in the particular report. An extensive amount of work was done in this investigation. It went so far as searches and seizures being done at VBS's offices. And so the procedures performed in this investigation were rather extensive. Now, the applicant made certain contentions in his arguments before the court. And of relevance was he said sections 136 to 140 of the FSR Act intended to ensure fairness in the investigation. This obliged the first respondent to observe the principles of natural justice and to afford implicated individuals the opportunity to be heard. There was, if you've read the report, there was a reference to him as a kingpin who has facilitated bribes to municipal officials with no shred of empirical evidence infringed his constitutional right to freedom of trade as a businessman. Now, basically, if you've read the report, there were several paragraphs in the report where certain findings were made against him. And the language used was, he was the kingpin behind it, and he facilitated various bribes. And in making those findings, the investigation relied on witness interviews that were conducted and information obtained from certain witnesses. They relied on their review of certain documentation, etc. And they made hard findings. Now, the report doesn't say that, on the basis of procedures performed, it appears that Mr. Msize may have been involved in certain things. However, we have not interviewed Mr. Msize for the following reasons, blah, blah, blah. Rather, it made very, very strong statements and used words like kingpin, etc. Now, what caused outrage to Mr. Msize in particular was that, this report was in the public domain. Reputationally, it was damaging to him. His argument was that as a businessman and a prominent figure, these statements, without giving him an opportunity to respond to these statements, were damaging to his reputation. Him and his family received threats. And so the consequences of these findings for him extended to more than potential legal consequences. So take the legal consequences aside, the consequences extended so far as his name being brought into disrepute in a process that he was not even allowed to be a part of. Pursuant to the report, there were certain interviews that were done by the lead on the investigation, again, substantiating these findings further by saying, well, I got evidence from so-and-so and I read the documents, and so yes, he was the kingpin, etc. And so that also outraged Mr. Msize more. The crux of his case was that the investigation failed to observe the Audi Alteram Partem rule. It failed to ensure that he was procedurally fairly treated, and it also, the investigators were biased against him He then made the contention that had he been approached, he would have cooperated to give explanations. Now, these last two bullets are very, very important because if you've not interviewed a particular individual during the course of your investigation, what is the reason why you didn't? And would you have a strong enough ground to defend yourself? Do you have a proper reason to say why you have not interviewed someone? There's a very, very big difference between approaching an implicated party for an interview and them turning you down versus you not approaching them at all. Because if you've approached them, at least your report will say, I did approach him on this date, and the request for interview was declined. What I've done in my investigations where requests for interviews were declined, I don't always just do it once. I sometimes do it several times. So I'll start off with an initial request for an interview. I'll follow it with, I know you've refused, but please note we're busy finalizing our report. I'd like to invite you for further interviews so that I could hear your side of the story. And it's further declined. But then you have to then be very careful when you're making adverse findings because you've not heard the other side. And over the years, I've done investigations where you interview the other side and you then start to get a more balanced view, especially where an investigation is not document heavily driven, where you get investigations where a lot of the work and a lot of the information you obtained is by way of witness testimony, because there isn't enough documentary information to go on. And in those particular investigations, when you start to interview the other side, you start to pick up sometimes a more balanced view. And in some instances, what may initially appear to be adverse finding turns out to either be an inconclusive finding, or it turn out to be a non-adverse finding because you've heard the other side and their version is the more probable. And so it's very, very important to get that particular balanced view when you're doing your investigation. The other important point to be made here is that when you're sitting in the witness box, which is the worst part of our job and the most stressful and not something I particularly enjoy, even if you know your investigation is foolproof, because they will find ways to target you and your family and your credibility and everybody and your neighbors. And that is what they will start to do first. It's a tactic in cross-examination, especially with criminal or when they're on the defensive, or where they're acting for an implicated party. So before they start attacking the merits, they start attacking you. And I'm sure you would have seen this, is every time I've been cross-examined, my character has been called into question. I've been told that I was biased. I've been told that I was not objective, etc. But you need to be able to defend your position by the work that you've done. And your report must also speak to that impartiality and objectivity, so that after spending a few hours fighting those fights, you come out the winner, because it's quite clear that it's contrived to try and attack the process and the procedure, and then you can fight about the merits. So these particular arguments are very important. You'll always, or often, or 90% of the time see it when you're being cross-examined, is your process wasn't fair, you didn't do this, you didn't do that, you didn't do this, etc. And so he raised these particular arguments, but there's a difference in this case, because in this particular case, he wasn't given an opportunity to be heard and to give his side of the story. Now, some of the respondents' contentions are quite important in this particular case as well. They raised as a defense that the investigation was a preliminary step which did not attract legal consequences. Section 136 of the FSR Act did not oblige the investigator to interview every person mentioned or implicated. The applicant failed to prove that failure to afford him a hearing rendered the findings and impute statements irrational. They were merely recommendations that further investigation had to be conducted. The failure to afford the applicant a hearing did not infringe his constitutional rights, and the applicant does not have a general right to be heard, and there's a general misconception that the requirement of natural justice to afford interested parties the right to be heard during an investigation. So these were the defenses that were raised. And automatically you can see that some of these are quite smart defenses. In particular, I'll speak about the one where it says the investigation was a preliminary step which did not attract legal consequences. Now, if you look at that particular argument, Are we saying that we will conduct an investigation, interview certain individuals, make adverse findings, and if we've not interviewed people about who form the subject of the report, our defense is that, well, when they sued or when they prosecuted, then they can defend themselves. Where's the objectivity in that particular process? I mean, that's the counter argument to that. Our reports have meaning. We are not just asked to do investigation to present one-sided findings or one-sided facts. Of critical importance to any forensic practitioner is impartiality and objectivity. And how are you impartial and objective if you've not given key people in your investigation an opportunity to be heard on the basis that, well, if there's civil action taken against them, then they can defend themselves. If they're prosecuted, then they can defend themselves. What if you interview these individuals and they explain away all of these findings in a reasonable manner that changes an adverse finding to that there was no substance to these allegations in the first place? And I've had investigations that I've done where I've interviewed I did an investigation last year where a whistleblower made certain allegations, and we did a preliminary investigation to see if there was substance to the whistleblower allegation. So the first 4 interviews that we did were with people that could provide us more meat or substance or information in relation to these particular allegations. And when we did those interviews, we found that there was substance or appeared to be substance to these particular allegations, which warranted further investigation. There were 3 people implicated in the investigation. When we conducted the further procedures and interviewed these 3 individuals, what initially appeared to be adverse findings were no longer adverse findings. There was a reasonable explanation for decisions that were taken. There was reasonable explanations for how things were conducted, etc., because the other side was able to give us context to these decisions. They were able to give us documentation which negated some of these allegations. And so it changed the lay of the land because we've now heard 2 sides of the story. And so it changed the findings dramatically. And that's a very, very important consideration to bear in mind. Okay, 2 minutes. Oh, okay, I've got 2 minutes. I'm in a rush. All right, there is a very important aspect of this particular judgment, and it's the quote that this particular judge said. He said in making his judgment that it's important in the interest of justice to extend the principle of the rule of law and rules of natural justice, even to those individuals who are suspected, like in this instance of wrongdoing by the investigator, being the individual's right to be heard before adverse findings, remarks, and conclusions are made in investigations, such as the one envisaged in sections 136 and 137 of the FSR Act. There is no merit whatsoever in the argument that the affected individual shall have the opportunity in proceedings which might be engaged in the future to clear his or her name, or that he or she may have recourse to a claim for damages. The judge went on further to state that an investigator in the position of the first respondent was, in my view, obliged to ensure that the rule of law, the rules of natural justice were observed as provided for in Section 33 of the Constitution and Section 3 of FAJA. It is a duty placed on him as the investigator, even if the authority would not have implemented any of his recommendations after receiving his report. This is very important. In my view, where an investigator knows or is expected to foresee that his findings, remarks, and conclusions will have consequences for the party on whose behalf an investigation is conducted, and for the party against whom findings will be made, he is obliged to listen to both sides, and the party who is likely to be affected by adverse findings is entitled to demand the right to be heard before an adverse remark or finding, conclusion, or decision is made against him or her. And that is a very, very important thing that the judge said, and that is important for investigation. Right? The order that was made was that the adverse findings, remarks, and conclusions were reviewed and set aside, and that it was found that the first respondent's failure to afford the applicant procedural fairness prior to the release of the report was unlawful and unconstitutional and violated the applicant's rights in terms of Section 34 of the Constitution. The next case I'll go through quite quickly was the case of Tiso Blackstar Group and others versus Steinhoff International. This is quite an easy case for us to go through. I have spoken about legal professional privilege at length. And so basically what happened in this case is a you all know about the Steinoff saga. An investigation was commissioned into the particular irregularities that were uncovered at Steinoff during the period 2019. The report was first published on in February 2019 and handed over during March 2019. Both Tiso and Amabungani requested the reports in terms of the Promotion of Access to Information Act. Both of their requests were denied on the basis that the reports were protected by legal professional privilege. Now, certain important things that come out of this particular case is that the now, if you know Tiso, they own the Sunday Times and other media publications, etc. And we all know the Amabungani. They basically identified the right that they sought to protect was the freedom of expression, which right includes the freedom of the press and other media, as well as freedom to receive or impart information or ideas. Now, the court in this matter held that the right to freedom of expression, amongst others, is a right that would entitle the requester to records held by a private body. Now, the court found that the refusal to provide the report limited the applicant's rights to freedom of expression, and ultimately the inquiry to be made by the court was whether such limitation was justified in terms of Section 67 of FIRE. Now, Section 67 of FIRE is the justification where you don't disclose or you can refuse a FIRE request because of legal professional privilege. And so Steinoff claimed litigation privilege as a basis for refusal of access, and this then required Steinoff to establish that the report was obtained or brought into existence for the purpose of submitting it for legal advice in respect of litigation, either pending or contemplated or likely at the time. And the court found that there were no facts placed before the court to support the assertion that litigation was in contemplation at the time of the appointment of PwC. And basically what this meant is that they said, no, Steinoff instructed a law firm to instruct PwC to conduct the investigation. And because of that, litigation was contemplated at the time. But there weren't enough facts placed before the court that at the time the investigation was started, there was the Hierkom Kak letter, because there was a SENS announcement at the time which spoke of PwC being appointed to do an investigation, but there was no other evidence, or that SENS announcement didn't make reference to the law firm, briefing PwC, etc. There was also the engagement letter, which said legally privileged and in contemplation of litigation, and the court found that just putting that on the engagement letter didn't necessarily mean that litigation was contemplated at the time. And that formed the crux of the court's judgment that Steinoff was required to produce the report to Amabungani as well as Tiso. And so the Steinoff's request or Steinoff's refusal to provide the report based on the prior request was reviewed and set aside, and they were directed to supply each with a copy of the report within 10 days of this particular court order. So that's quite an important case, very interesting one, quite an easy read. Sorry I did rush through this one a bit, but I did speak a lot about the concepts of legal privilege earlier, and so all of those considerations came to bear in mind. And then what does this mean for investigations? Always give thought to your investigative procedures. Every step that you take must have a purpose, and so think about what it is that you're doing before you do it. Ensure your impartiality and objectivity and act accordingly. Make sure that nothing you do can impact on that, or that you can be accused of not having acted impartially or objectively, and make sure you understand fully legally privileged, what legal privilege means versus confidentiality. With that, thank you very much. I'm not sure if I have enough time for questions, but
okay, if we can allow for one or two questions, or anybody quiet and angry. Thank you, Zakir. I appreciate. Now, even my wife, like the car off of the pavement, the damage of the car, after what the hell did you do? She said, I can't do legal privilege. Meaning, stay out of it, you're going to get in trouble if you're asking more questions. So thank you, Zakir. I want you to just come to the front so we can just exchange. is hierdie ou vier. Dan is hy gaan staan daar. Ek het nie dit aan.
Okay, good morning, everybody. It's a great privilege standing here. I'm glad that Zaki spoke before me. So the more he speaks, the less I have to say. Specifically in my world, I only use English as a defense mechanism. And secondly, I get paid by the hour. So, but what I'd like to do is to expand this issue a bit more. And I'll do it for a very particular reason. And that is because of you who are sitting here in front of us. Members of the ICFP, a lot of you are the future. All of you are the future of the industry. A lot of you were exposed to studying the in Potch from as early as Aletta, Jacob. When was that, 2005? So what we did at those times, we said, this is this new animal, how's it going to look? And to tell you that there's a career path for you, and what we didn't tell you is that content needed to be given to that career. And that is what I'd like to focus on today, by specifically referring to what we're currently doing at the ICFP regarding our standards that we are developing. And I will have a specific focus on how those standards apply to the concept of the Alteram Partem rule. Now, as I said, the ICFP was established in 2010, and COVID ensured that we didn't have a proper celebration of it. But for me as a lawyer, I have to think 2 seconds about what it means. And now we have an entity that's 12 years old. Now, if you bring it back to a person who's 12 years old, how would they look like? Okay, that is maybe a person 12 years old trying to find his identity. My wife said that is a very old picture. It's of the 80s. Now, I agree with her because I did Google a 12-year-old, and then a warning for pornography jumped up. Because a hipster who's sitting below your hips is not supposed to be shown. But in a sense, what I'm saying about this picture is, in this entity, this animal is a teenager. And to a great extent, it's important for us to give direction, to see, listen, what are our values? What drives us? How do we do our business? And that will be illustrated by referring to whether we're going to hear the other side or not. So when we ask these existential questions, who am I? Where do I fit in? What purpose do I have? The guidance we needed. I try to be a bit more philosophically by referring to a very old book, that of Victor Hugo, Les Miserables. The Americans made a couple of movies of it. This one with Hugh Jackman. For 2 reasons, don't go and watch the movie. Because from Hollywood, they messed the whole story up. And secondly, it's maybe a good idea to do some proper reading. When I'm looking at report writing, this is a very good book to start with. But what's important of this character, the main character in this musical, in this story, is that of John Valjean. Remember, a person was put in jail because he stole bread, actually to provide for his sister. Eventually was released from jail. He was taken in by a priest, and then he stole from the priest. when he left with the goods he stole, he was confronted by police with this bag and said, "You have to go back to jail. You've stolen again." But then the priest came and said, "Listen, I actually gave this stuff to this guy. He didn't steal it." And that moment, this person's life changed. And he became an inspiration of hope. And I don't want to tell the whole story and read it, but what is important in this, the departure in stance that I have is, we are agents of change. That's what forensic does. Remember that. We are here to create hope, because this country are in very great need of hope. Lessons from state capture and rampant corruption. Okay. Firstly, is the role that professions play. Auditors, lawyers, advisory firms were very clearly identifiable enablers of corruption. Okay. There's a lot of criticism, whether they are doing their work, how they discipline their members, or do they have the time it takes. Now, on the one hand, that's the negative side. But if you look at the positive side, a professional body is the ideal vehicle to protect society and you as individual. It gives a corporate body that gives standards, that is a voice for your profession. That is a voice for the role you are playing in society. Often a profession has a unique character that transcends the borders of the country. Even if you have a corrupt government, you can say, listen, but we have certain rules that we apply that are internationally required from us. Okay. So that autonomy professional body gives is very, very important. And we need to, all of us, to take ownership of this to make sure that the rules we have, that it serves the greater good. And that's why the issue of self-regulation is very important. I'm going to refer to it a bit more. A professional body serves the constitutional role of an entity that provides checks and balances for constitutional powers. Zakir has now mentioned the one side of it, to listen and to address the rights of the accused. But what about the victims? What about our whistleblowers? What about the thousands of people who suffered as a result of what happened at DBS? Or the 1.5 trillion rand that we lost as a result of state capture? 1.5 trillion rand. What about that side of the story? And what is our role in that regard? An example is that of independent lawyers. In its essence, if a lawyer do what he's supposed to do, and that is to be a servant of court, not of his client, but a servant of court, then the lawyer fulfills his role. So, in terms of the ICFP, where are we on our journey, except for having blue hair? Okay. In the early 2000s, we identified the need for this profession for standards, accreditation, based on a drive for quality and integrity to cohere and create a credible profession. And that was the ideal. In August 2007, not far from here, we had a meeting with a lot of professionals. I can tell it because I was there, I'm very old. 15 meetings later, 2010, it was decided to create this professional body. The primary objectives of this entity were as follows. to define the borders of and careers within the industry, benchmark training, set a minimum code of conduct, set generic minimum standards of operation, develop career paths, monitor compliance and continuous professional education, vet members on an ongoing basis, assure sufficient cohesion and convergence in the industry to build public confidence, and to develop a brand for the industry that is trusted and recognized by the community. See the emphasis here: trust, confidence on what this profession stands for, what we wanted to do. It's also envisaged in our vision and mission to be a respected self-regulator. Our mission, the mission of the ICFP is to cohere, coordinate, and self-regulate. And manifested in its primary purpose is to cohere the emerging industry in South Africa, coordinate key initiatives to develop the industry, to serve the interests of the commercial forensic practitioners and society by upholding internationally accepted professional standards and integrity, and the preeminence of ourselves nationally as well as internationally, and to deliver competent entry-level members with relevant skills. That's what we set out to do. Some broad principles as a self-regulated body: to exist at the request of a profession, to be independent, to accredit individuals, to have active support from the industry, has relevant and recognized experience, and to ensure that there are serious consequences for non-compliance. Why am I giving this speech? Why I'm sounding like a preacher? Because we need to take ownership of the ICFP. We need to take ownership of the body that takes care of our professions, of our careers. And why is that important? Because at this point in time, we are going to show you our draft standards. Question is, like I always ask the students, did you do your homework? Did you have a look at the standards? Did you give your input? Okay. This is supposed to rule our conduct going forward. This is what you will be cross-examined on if you have to testify. Now, there's a lot of ideals I've stated. Let's look at what have been achieved by the ICFP this past years. As I said, 2010, ICFP was incorporated. We developed a membership criteria. So now we know who can be members. We have that whole issue about grandfathers. 2011, the bylaws were completed. We had the first annual conference addressing the whole issue of training. 2012, had our first member development session. This is 10 years later. You're attending one of those entities. The minimum requirements for the qualifying examination were set. We had the first newspaper, also addresses education. 2013, expanded on the qualifying examination. 2014, added to that. 2015, we registered with SAPQA as a professional body, obtained professional designation. 2016, our CPD policy, Center of Excellence, and in 2019, the board started with a very complicated process of developing professional standards. Where are we in that process? Let's have a look at it. So, as I said, the board established a standards committee, invited interested members to join, to participate in the process, established some subcommittees, which were inter alia required to conduct research relating to the subject matter, consider international standards, and compile a proposed standard. That's the basically the mandate. 4 subcommittees were established addressing certain standards. tribute standards, client engagement acceptance standards, standards relating to information collection, and reporting standards. Of these four, three are in a relatively far developed stage. One is not exactly where you would like to have it. I'm going to refer to some of them. Now, before looking at the standard, it's important that we understand what the nature of forensic investigations are. And Zakir already referred to it. I just want to add one or re-emphasize 2 or 3 items. The fact is that we must remember that we are a unique profession. We often have to manage the understanding and frustrations our clients may have. Remember, if you discover that your business, a lot of money has been stolen, you can expect your client to be angry and expect that they want to see something happening. That's why they came to you. And that needs to be managed. They must understand that we do not walk on water. Okay. We are not the police. We are not the judge. We have a very particular role. Zakir referred to that. Understand that you need to consider where by the port will end up. Okay. It's even is very clearly described by Zakir. You have to foresee, even if you're busy with the planning of what is in your client's eyes simply a disciplinary matter. What happens if you see, but well, in excess of 100,000 rands were stolen or defrauded? Then it automatically has to become a criminal matter. There's no choice. Then you also refer to the fact that we are working in a very litigious environment. People have a lot to lose. They are going to jail. They are going to do their best to stay out of jail. Okay. That may entail a couple of things. Fighting nicely, attacking you as a person, your credibility, but also something that's becoming more and more concerning in this country, physically attacking our witnesses. Actually die. We need to take cognizance of that as well. We need to understand that we work in a legal context. Understand what is expected from us, the elements of a particular crime, know your rights, those of your client, and respect those of others. That is the key that needs to be considered. Then we can ask questions. What's the aim of our investigation? I quickly refer to it. Is it ethical? In the past, I used to tell my clients, what does my client want? Get my money back as soon as possible. Get rid of that employee, that stuff. But is it ethical to say that is what my aim is? I will assist you to get rid of a person. Are you still objective? What will happen if your client is called and say, what transpired at that very first engagement meeting? What did this forensic guy tell you? No. My lord, he told me that you will get rid of this guy. Okay, end of story. Okay. It's just as good as having a VBS front page on your report. Okay, so that is what we say about how we need to be clear on our role in legal proceedings. Okay, the wording we use in reports, Zakir referred to them. I quoted a number of these interesting cases. You can have a look at it. Majola versus Times Media, stating now therefore the client or the defendant is guilty of the crime of theft. that sentence was derived from what? A report of a Big Four auditing firm. Okay, it didn't end well for them. Or versus Solé, the Lesotho matter, where PwC was cross-examined, John Roux, and all that. Okay. He was cross-examined on his views of the words appears and apparently. Okay. But compulsory reading, all 90 pages of that judgment for all of us, he explained very clearly why he uses that words, saying that he is not observing the duty of court. He's not making the judgment. He tells what he sees, the facts and only the facts. We refer to Macau matter and so forth. We need to be objective and independent collators and communicators of admissible evidence. History has shown us that presiding officers easily lose confidence in the merits of reports when they find that the report is not properly researched, objective, and well motivated. Okay, one thing is for certain, you can expect to be rigorously examined in court over your work. Thus, your ethics and professionalism will come into play in a big way. Professionals should do the best job possible for the client, but the way they do that is by being independent, objective, maintaining confidentiality, avoiding conflicts of interest, and not accepting any contingency fees based on the outcome of the case. It's very nicely summed up by one of our honorary members, Jan Swanepoel. A good forensic practitioner is somebody who has an inquisitive spirit. He has to have integrity. You cannot approach a case with prejudice. You have to stay objective. Put the facts in a report, not your opinion. Any reader with some degree of intelligence would be able to see the person is guilty. Work with facts and allow it to speak for itself. So, when developing these standards, we had to put down some considerations. Firstly, the need to protect the public interest by ensuring consistency to a minimum standard of practice. We did not intend to codify practical rules and to address all matters associated with engagements, but rather provide conceptual guidance. Okay. We try to assist with the application of professional judgment and to be principle-based. I want to stand still here for a moment. This means that this set of standards will not be a detailed, step-by-step audit plan. Okay. It will not explain to you, if you wake up in the morning, first open your eyes. Okay. That is, you'll not find it. It is principle-based. Why? Because, as Zaki referred to it, each forensic investigation is unique. The nature of your appointment may differ. From being appointed by a private entity working as an external consultant, or you may be an in-house forensic person working at a agricultural entity in the Free State. Okay. There's a lot of differences. You may be seconded to the SIU or the AG or the police. Then there's a whole different set of rules that apply. We cannot cater for all levels. You need to be a professional that's prepared to apply guidelines, principles as good as you can. So the subcommittees were guided by the following relating to proposed standards. Commercial forensic practitioners should be inspired by the proposed standards and not interpreted as being prescriptive. We are building this car as it is driving. Okay, we don't want to scare all of us of it. Okay, The proposed standards should be a guideline for practitioners. It was decided to initially focus on the development of general performance and conduct standards, and that these standards would form the foundation of the development of further, more specialized, detailed, specific standards. Okay, so this is a starting place, okay, a basis from which we can work. Lastly, before I'm going to overlay, the perception on the issue, perception and the issue of trust. If I tell you about lawyers, I'm a lawyer myself, immediately you'll start laughing. These guys can't be trusted, keep them away from money. Not only don't they have the ability to do proper casting, they will steal whatever is there. Okay. That's what we understand of it. Okay. But it has an impact on the perception of the profession, on our own lives. And I want to refer to people who are working very closely to us, and that is the police. So the Stats SA have this victims of crime survey. This is a perception-based survey that's done among the public. So they went annually to the public, asked them, how do you perceive X and Y in the country? Well, what is notable of this study is the decline in victims reporting of crime. For example, between 2013 and 2014, 19% of victims reported their stolen vehicle, that their vehicles were stolen. 6 years later, only 79% did so. Why on earth won't you report that your car is stolen? But it's not only that industry. Similar declines were found in terms of hijacking. 100% down to 78%. Why would you want to report a hijacking? Isn't it terrible to be hijacked? Assault, which we know were low, 67 to 41%. Okay, I didn't even quote rape and those type of things. Why is this happening? That's the question. What does it tell us? We don't trust police anymore. We don't expect something from them. Okay, except for going to stand in the long queue. I did last week getting my firearm license renewed. It is when put in a graph, you can see, so trust in the police declined from 63.9% to 41, 39 to 54% in terms of the police. But worries me even more. The same question was asked, how do you trust the courts? And this declined from 63 to 41%. My take on this, if you ask the normal person, that's what happened here in the streets, do you trust the courts? What does it mean? They don't trust the system anymore. If you don't trust the system, what are you going to do? You're going to take the law in your own hands. Or you're going to expect your forensic guy to do it. Okay. So if you go and look at murder statistics for the police, you know what's the fourth highest reason for murder? Is it vigilantism or mob justice? Okay. People are killing because they say, I'm going to take the law in my own hands, not trusting the police anymore. So this one set of guys that does it. Recently in the conversation, another similar analysis was done. This is from 1998. Trust in the police still now. Now, there's some problem, like here, I can't read anymore. That, well, the fact is, in this 20-year period, trust in the police has always been low, always been below 50%. You can see there that decline from 2013 to 28%. When was that? It was Marikana. And then you can see at least we have some improvement. Interesting, the improvement 2018 to 2020. For some reason during COVID, the public still trusted the police. I beg to differ. I simply cannot remember or forget our commissioner standing on the beach with armed policemen with semi-automatic weapons chasing a girl in a bikini from the beach. Okay, I struggle to get past that now. But after that, 34 to 27%. All-time low, that was KZN violence at last. Okay, that's where we are. This morning when I woke up, by the way, what did we see in the newspapers? The police themselves, 53% of police themselves say, my colleague cannot be trusted. Okay. Okay. What these guys did, they said, what are the factors affecting confidence in the police? How public experience crime, the experiencing of policing, how were they treated? Well-publicized instances of public abuse and failure, perceptions of police corruption, perception, fairness and effectiveness. How was it treated? Was it effective? Was it fairly treated? Similar perceptions that the police treat people disrespectfully, lack impartiality and in their decision-making or transparency in their actions. Why am I referring to this? I'm not bad-mouthing the police. I'm very good. My best friends are in the police. Why am I referring to this? Because we are associated with them. We're in the same boat. But even more so, we must learn from their mistakes. If we are not impartial, if we mistreat people, we will not be trusted. If you're not trusted, you will not be appointed to do R1 million charge R1 million for investigation. That is the basic of it. That's what we need to understand. That's why how we do our work is very important. That's why our rules are important. Okay, so last picture. This is the students know it. This is a painting. I still have my last drawings here from a Zoom session. Mythology, Greek mythology. So remember, the Greeks believed the gods are up in heaven, we are on earth. But for them to be able to communicate with us as earthlings, how did they do that? They had a messenger. Who is that messenger? Does anybody know? This guy, Hermes. It's a messenger of the gods, but also the gods of trade, thieves, travelers, sport, athletes. You'll remember that Adidas, and that's where Nike derives it from this guy's headgear. But what's important? For the earthlings to trust that this is the message that's coming from the gods, what must Hermes do? He must have integrity, must be independent. He shouldn't put his own perception to a certain message. He shouldn't put his own interpretation to it. He simply has to collect the message and deliver it. And that is in essence what we need to do. The whole message, not part of it, the whole message. Okay, that is what I wanted to say about that. We have three documents in terms of standards. Firstly, the attribute standards. I'm only briefly going to show you where these documents refer to the issue of hearing the other side. The attribute standards is about all these ethical issues, how we do and articulate our shared aspirations and commitments. composing of 5 principles: integrity, objectivity. What do we say about objectivity? Commercial forensic practitioners exhibit the highest level of professional objectivity in gathering, evaluating, and communicating information about the activity or process being examined. CFPs make a balanced assessment of all the relevant circumstances and are not unduly influenced by their own interests or by others in drawing inferences and conclusions. Then confidentiality, we refer to that, that contractual issues, like you spoke about that, competency and legality. Of course, we need to comply with what the law says. In more detail, it's spelled out. I'm not going to read all of it. In terms of integrity, same goes for objectivity. What does it say? Commercial forensic practitioners shall refrain from any activity or relationship that may impair or be seen to impair the unbiased assessment, including activities or relationships that may conflict with the interests of the institute. Secondly, not accept anything that may impair or be seen to impair the professional judgment. And lastly, an important one for us, disclose all material facts known to them that if not disclosed, may distort the reporting of activities on the investigation of review. Basically, not difficult, all the facts, not that what you think is important. Maybe I should say one thinking about it. I was once challenged in a matter. What happened? I interviewed a politician. She took money from a political party. And what she stated when I interviewed her was so far-fetched. It was so a lot of nonsense. I didn't even bother to write it down. Okay. But the problem is, when I was cross-examined, they asked, but what did this lady say? I couldn't recollect it. Okay, because I could, but I couldn't prove it, what she said. And that is the issue about it. Because I was biased, I decided to do the court of the work of the court. The court should make that judgment, not you yourself. If this person is lying, it's wonderful news. Okay, give them a gold star. Okay, because that is what needs to be put in front of the judge. Confidentiality, competency, adherence to the law and professional standards. That is what the case law refers to. Now, in terms of information gathering standards, I'm going to point out how far this issue of hearing the other side goes, actually. So this, I'm just taking you through this so that you can at least say you had sight of the proposed standard. First general principle that's important regarding the gathering of information is that commercial forensic practitioners should gather and consider both inculpatory and exculpatory information. So can you refer to it? Okay, that is what we're saying in this draft at the moment. Hear the other side. That what is good for your client as well as that what is not good for him. Okay, you cannot decide to swing the matter before it is actually heard in court. Then it is advisable that the CFP perform thorough planning prior to commencing with gathering information. Why am I alluding to this? So because when you plan, you make sure that you plan to visit this accused and his family and get the version. More so that you prioritize it. Because if you run out of time and that you said, listen, I have measures in place to make sure that I at least hear the side of the story. It's mentioned. Then the issue of the confidentiality of information should be safeguarded throughout the process of gathering, analyzing, evaluating, documenting, and retaining information. Why do I refer to this? So, my concern is, so when we go and speak to person X, tell them, what is your side of the story? You should be very wary, because in my opinion, we have a very important duty, not only in terms of confidentiality towards our client and his information, but to our witnesses, those who support us, that when you do speak with this criminal, that you don't put your witness in danger and don't compromise the investigation and the eventual case in that process. So this is the balance we need to find, and that is a very difficult thing to do, and I'll explain to you a bit later as well. In terms of gathering information, it is vital that commercial forensic practitioners gather information from various sources in order to test the credibility of sources of information. Here again, alluding to the fact that both sides should be heard. In terms of conducting interviews and interrogations, it is very interesting. We don't have a specific policy at this point in time, because we understand that it still needs a lot of work and thoughts needs to be put in place. But so the bad news is, at this point in time, there's no clear guidance that we can give, and you in front of us should, and hope, and my plea is that you assist in this process to develop these policy as well. In terms of whistleblowers, we already have something in place, and I'll quickly show that to you as well. Then, analyzing and documenting gathered information. Again, when you work with that, now you have all this information. How do I treat it? How do I weigh it? It is advisable that commercial forensic practitioners also document the following. Okay, that, I'm not going to quote all the things, that communications were held with the client, witnesses, suspects, and third parties. Okay, make sure that you document it and have record of such activities. In terms of working papers, remember your working papers may, in certain instances, be disclosed to the other party. Okay, so if you were angry at a point in time and went through an email or a document and said, this idiot or criminal or whatever word you want to use, that may end up in court. That may impair your impartiality and objectivity. Okay, make sure about that in terms of even your working papers. There's a couple of references to that. Maintaining chain of evidence, not really issue in this regard. And as I said, different further practice notes will follow on interviews as well as whistleblowers. Now, in terms of report writing, this is where it becomes very interesting. What do we say about the qualitative characteristics of a forensic report? The context of the report must reflect that the investigation and compilation of the report were conducted in an objective and independent manner. Okay, and this is very technical. I often use the example, and I'm not going to show it because of Chris has this recorded, because it's I may be extradited from the country by using this example. Even our state capture report, that was a very good report and was key in changing things, I have concerns about. So go and read the first introductory page of that report. What will you find? that we refer to President Zuma, Minister X and Y. There's an advocate and misters and a lot of people who's referred by their titles and proper names. And then the Gupta, not Mr. AJ Gupta or the Guptas. On that very first page, I can say that writer of that report was not objective. No. And that is the problem. We tend to make that small mistakes. And lawyers are paid, and Zaki told you that, to find those small mistakes, to attack you, your credibility. I promise you, most lawyers, they can't do casting. You won't be challenged on your numbers. Okay, you can rest assured about that. But on all else, you will be challenged. The report must reflect adherence to constitutional legal requirements. That is what we spoke about earlier today. The report should reflect all relevant evidentiary material, information, and views collated and considered. In instances where confidentiality, secrecy, and legal privilege is applicable, it must be clearly indicated in the report. You can read in detail what it says, how it is explained. It doesn't differ a lot from what was you heard earlier this morning. Okay. Then the issue of draft reports. It often has have the practice of sending draft reports to our client. What's the purpose of sending a draft report to your client? To make sure that it says what I want to hear? No. To make sure that there's not material mistakes, spelling of a person's name or a job description, those types of, that is the reason for that. But do we send our draft reports to the accused? Should it be sent to them? Okay, again what I'm saying, the moment you start thinking about that, my short plea today is, there's a lot we can say about that, is at least think, if you do a full report for a client at the entity, that may be done with a lot of recommendations on procedures, on policies, in-house for the company. It may refer to disciplinary matters or whatever. But that report may also end up in a criminal matter, where we have another type of animal. That's a person who kills witnesses. Okay. And then something that can be said without thinking about the consequences of it in your big report can have a detrimental effect on the person's life. That is the issue I want to raise about that. Okay, so that is the issue of reports. I don't want to take you away from your lunch. We also drafted a draft whistleblowing practice note. The protection of whistleblowers is very important. It's not adequate. There's a lot of research that's been done in that regard. Blueprint for Free Speech, stating that the current framework is not adequate to meet the challenges of a growing corruption and fear of retribution in South Africa. 2021 Freedom in the World report referred to Babita Deokaran. It suggests the protection measures for whistleblowers are weak. The Open Democracy Advice Center described the situation regarding whistleblowers as harrowing. The Director for Public Prosecution, Samila Betoy, after the shooting of a regional prosecutor in Umlazi last year, December, said the increase in attacks on those fighting for justice in our country should concern all of us. We need to significantly improve the protection of criminal justice officials, whistleblowers, and witnesses in South Africa. The rule of law depends on it. The future of our country depends on it. And we owe it to these brave men and women. This will require a multi-stakeholder effort driven by government, and the time is not on our side. I want to add to that. It's an effort that we as an institute, we as professionals should also take. Yeah. The moment we, and it's not if, it is when, forensic investigation will be linked to a whistleblower that died, people are going to trust us. We can't do investigations without witnesses. It's crucial. I already showed you earlier the impact of trust I have on the police and the possible impact that it may have on us. So, read the draft practice note. Please apply your mind. Give input on it if necessary. It was drafted from the UN recommendations regarding peacekeepers in conflict zones. So it's a complete overkill, but it's necessary. Right. That is so please see it in that context. And then once it is approved, I think Chris will say a few words more about the practice notes, where we are, specifically regarding what will be tabled at the coming AGM and the conference. That those timelines is very important. My plea, in short, is that we be involved in this process, take ownership of it. It is our profession. We need to protect it. Then a final word. So if you have time this weekend, go and read the book or watch the movie. At the end, near the end of this, the policeman commits suicide, and he is confronted by this issue because his whole life he was dedicated to chasing this guy that actually reformed himself, but he couldn't make the change or to understand that there is a balance that needs to be found between the rule of law, applying rules, and the interest of justice. Okay. That is a very important concept to understand, that there needs to be a balance between these two. In short, that, I think something that we can learn as well is, why are we doing this work? It should be more than just driving around in a nice car. What we're doing is important for this country and for our kids. Okay, thank you so much. Thank you for the time.